My wife's attorney looked at me across the conference table and said, "Mr. Aldrich, Deborah has been acting in your best interests throughout this process." I said, "Which process?" She said, "The asset protection structure we've been developing. It's entirely standard for people in your position." I said, "What position is that?" She said, "Retired. Significant assets. Vulnerable to litigation and financial risk." I said, "I have been retired for 2 years. I have no pending litigation. I have no financial risk I am aware of. What specifically are you protecting me from?" She looked at Deborah. Deborah looked at the table. I said, "I'll ask again. What are you protecting us from?" Neither of them answered. I had been married to Deborah for 41 years. I had sat across from her at breakfast every morning for 41 years, and I had watched her face through the full range of what a long marriage contains: joy and grief and anger, and the particular exhaustion of shared difficulty and the particular peace of shared comfort. I knew her face the way you know a place you have lived your whole life. I had never seen the expression she was wearing in that conference room. It was the expression of someone who has been caught not at something cruel, but at something she had convinced herself was kind, and who has not yet decided what to do with the gap between those two things. I picked up my folder. I stood up. I said, "Deborah, when you are ready to tell me what is actually happening, I will be at home." I walked out. What I did not tell her, as I walked through the glass doors of Melanie Holt's law office on a Tuesday morning in March, was that I already knew what was happening. I had known for 3 weeks. I had spent those 3 weeks making sure I understood it completely before I said a single word. This is the story of what happens when a wife forgets that her husband spent 35 years running a school, which is to say an institution that survives entirely on trust and collapses entirely when trust is broken. My name is Dale Aldrich. I am 69 years old. I was born in Ann Arbor, Michigan, the son of a public school teacher who believed, with the particular conviction of someone who has spent their life in a classroom, that the quality of a child's early education determines more about their future than almost anything else that will happen to them, and that this fact is both the most important thing most people fail to understand and the most important thing most educational institutions fail to act on. I became a teacher myself, which surprised no one who knew my father, and I taught 3rd grade in the Ann Arbor public school system for 7 years before Deborah and I moved to Columbus, Ohio in 1989. I spent 2 years teaching in the Columbus public schools and 1 year thinking about what it would take to build something better. I founded Aldrich Academy in 1992 with a leased space in a converted Victorian house in the Clintonville neighborhood, 8 enrolled students, 2 teachers, including myself, and a philosophy of early childhood education that I had been developing since my 3rd year of teaching and that I believed was genuinely different from what most schools were doing. The philosophy was not complicated. It was built on the understanding that children learn best when they feel safe, that they feel safe when they are known individually by the adults around them, and that knowing a child individually requires small class sizes and long relationships and the kind of patient attention that large institutions find difficult to sustain. Over 35 years, Aldrich Academy grew from 8 students to 112, from one leased Victorian house to a purpose-built campus in the Upper Arlington neighborhood of Columbus. Every classroom had been built with the specific pedagogical requirements of the age group it served in mind. I sold the school's operating organization 4 years ago to a nonprofit education foundation, retaining ownership of the building, which the foundation leases from me. The building is valued at approximately $3.2 million. I retired at 67. Deborah retired the same year. We had been married for 39 years, and we had built what I had always believed was a partnership of genuine equality. 3 weeks before I walked into Melanie Holt's conference room, I had begun to understand that my belief had been incomplete. Deborah is 67 years old. She is a small woman with her mother's particular quality of stillness, the kind of stillness that people mistake for passivity until they have known her long enough to understand that it is actually a form of patience, a capacity to wait for the moment when action will be most effective rather than merely most immediate. She was a pediatric nurse for 32 years, and she was, by every account I heard, exceptional at it. Not in the dramatic way of people who perform heroically in crisis, but in the sustained way of someone who shows up every day and does careful, attentive work. I loved her for this. I have loved her for 41 years, and nothing that happened in the months I am about to describe has changed that, though it has changed other things. After she retired, Deborah became interested in financial planning. She began reading about estate planning and tax structures and attended 2 seminars on wealth preservation. She developed opinions about how our assets should be structured that I had engaged with but not acted on because I found the proposed structures more complex than our situation required. I did not understand, until 3 weeks before the conference room, that she had been developing those opinions in consultation with an attorney I had never met. The first sign came on a Thursday evening in January when I was going through the mail on the kitchen counter and found an envelope addressed to Deborah from a law firm I did not recognize. The name on the envelope was Holt & Associates. The return address was in the Short North neighborhood of Columbus. I left the envelope on the counter. I did not open it. I have never opened Deborah's mail, and I was not going to start. But I noted the name. 2 days later, I found a second envelope from the same firm, and on the following Tuesday, a document that Deborah had left on her desk in the study, partially visible beneath a legal pad. I could read enough of it to see that it was a draft of something called a revocable asset transfer agreement, and that the transferor named in the document was Dale Aldrich. I had not been asked about any such document. I had not seen a final version. I had not been told that any draft version existed. I stood in the doorway of the study for a long moment. The document was on Deborah's desk, and I was in the doorway, and there was a distance between me and the full text that I could have covered in 3 steps. I did not take those steps. I went back to the kitchen and made coffee and thought about what I had seen and what I had not seen and what the difference between those 2 things meant. Then I called my attorney. His name was James Obata. He had handled the sale of Aldrich Academy's operating organization and had prepared the lease agreement with the Education Foundation and had updated my will and estate documents when we retired. He was 61 and methodical, and he had a quality I valued above all others in an attorney, which was that he never told me what I wanted to hear. He told me what was accurate. I described what I had seen. The envelopes, the partially visible document, the conversations Deborah had been initiating about asset restructuring. James listened without interrupting. When I finished, he said, "Dale, what does your current estate structure look like?" I told him. The building and property were held in my name. The lease income was deposited to a joint account. The retirement savings were in individual accounts. The will divided everything equally between Deborah, our son Nathan, and our daughter Claire, with specific charitable provisions for the scholarship fund I had established in honor of my father, James said. And the building specifically. What would happen to it if you signed a revocable asset transfer agreement that named Deborah as the transferee? I said she would have the authority to transfer it. He said, yes, and if she then established a separate legal entity to receive the transfer and that entity had additional signatories, I said she could move the building without my further involvement. He said, depending on the specific language, yes. I was quiet for a moment. He said, Dale, I want to pull the corporate and property records. Will you give me a few days? I said, take what you need. James called me on a Friday afternoon, 4 days after our first conversation. He asked if I could come to his office. I said I could. I sat across from his desk and he placed 3 printed documents in front of me and he said, I want to walk you through these in order because the sequence matters. The first document was a corporate registration. A limited liability company had been formed in Ohio 3 months earlier under the name Aldrich Property Holdings, LLC. The registered agent was Deborah Ann Aldrich. The sole member, as listed in the operating agreement James had obtained through a records request, was Deborah Ann Aldrich. I had not been informed of the formation of this company. The second document was a letter of intent, undated, between Aldrich Property Holdings, LLC, and a commercial real estate development firm in Columbus called Meridian Development Group. The letter described a proposed acquisition of the Aldrich Academy campus property at a purchase price of $2.8 million, contingent on the transfer of clear title to Aldrich Property Holdings, LLC. $2.8 million. The building was worth $3.2. The letter of intent was for $2.8. I looked at James. He looked back at me. The third document was the draft revocable asset transfer agreement that Deborah had apparently commissioned from Melanie Holt. James had obtained a copy through channels he described as routine research. The document proposed to transfer my ownership interest in the building and property to Deborah, citing as justification my approaching age and the benefits of consolidated asset management during the retirement years. I said she was going to sell the building. James said she was going to acquire the building through the LLC and then sell it to Meridian for $2.8 million. The $400,000 gap between the market value and the sale price is consistent with a pre-negotiated arrangement that benefits the buyer. Whether any portion of that gap was intended to benefit Deborah or anyone connected to her, I cannot say from these documents. I sat with that for a long time, I said. She needed my signature on the transfer agreement. James said, yes. Without it, she has no authority over the building. I said, and the transfer agreement was drafted to look like estate planning. James said, it is framed entirely as a protective measure for your benefit. I said, how long has this been in development? James said, the LLC was formed 3 months ago. The letter of intent appears to predate it by approximately 6 weeks. Melanie Holt's firm has been engaged for at least 4 months based on the billing records I was able to identify. 4 months. Deborah had been working on this for 4 months, while we ate breakfast together every morning and walked the neighborhood every evening and talked about Nathan's children and Claire's garden and the particular satisfaction of a retirement that was turning out to be better than either of us had expected. I said, James, what do I need to do? He said, first, nothing visible. Don't change anything about your behavior. Don't raise the subject with Deborah. Don't indicate that you know anything. I said, for how long? He said, until we have protected the building, which I can do in 10 days. I said, do it. What James built over the following 10 days was straightforward in structure and thorough in execution. The first thing he did was place the Aldrich Academy building and property in an irrevocable trust, the Aldrich Educational Trust, with myself as trustee and Nathan and Claire as co-trustees, whose written agreement was required for any transaction involving trust assets. The trust contained a specific provision stating that the property could only be used for educational purposes for a period of 20 years, which effectively eliminated its value to a commercial developer of the kind Meridian represented. The second thing he did was terminate the LLC. Aldrich Property Holdings had been formed by Deborah without my knowledge or consent as a vehicle for a transaction I had not authorized. James filed the dissolution paperwork and notified the Ohio Secretary of State's office. The third thing he did was contact Meridian Development Group directly and inform them that the Aldrich Academy campus property was held in an irrevocable educational trust, that no transfer of the property was authorized or contemplated by the trust, and that any transaction premised on acquiring that property was not viable. Meridian's response arrived within 48 hours. They withdrew the letter of intent without comment. James called me when the trust documentation was finalized and the LLC dissolution was processed and the Meridian withdrawal was confirmed. He said, Dale, the building is protected. Nothing can move it without the written agreement of you and both of your children. I said, thank you. He said, are you ready for the next part? I said, yes. He said, how are you going to handle the conversation with Deborah? I said, I am going to let her tell me. He said, and if she doesn't tell you voluntarily? I said, then I will give her the opportunity in a setting where her attorney is present, which will make it easier for everyone to be precise. He said, when? I said, soon. 3 days later, Deborah told me that Melanie Holt had been helping her with some estate planning matters, and that she thought it would be useful for me to meet with Melanie so we could discuss some options together. She framed it as something she had been working on for me, a gift almost, the kind of practical care she had always brought to the management of our shared life. I said I would be glad to meet with Melanie. The conference room at Holt & Associates was on the 4th floor of a building on High Street in the short north. It was a pleasant room with good natural light and the kind of neutral professional decor that is designed to make people feel comfortable while discussing uncomfortable things. I had been in many such rooms over 35 years of running a school. I had sat in them with parents who were angry and parents who were afraid and parents who were both, and with teachers who needed to be let go and teachers who needed to be retained, and with the occasional attorney representing one party or another in a dispute about something that mattered to the parties and was routine to everyone else. In the room. I was not uncomfortable in that room. Melanie Holt was 51 years old, well-dressed, and had the particular professional composure of an attorney who has conducted enough difficult conversations to have learned how to begin them in a way that gives everyone present the impression that the outcome has not yet been determined. I knew that impression was not accurate. Deborah sat to Melanie's left. She was wearing the blue cardigan she wore to occasions she considered significant. She looked at me when I came in with the warm and slightly anxious expression of someone who is hoping a conversation will go the way she has planned it. Melanie began by thanking me for coming and explaining that Deborah had been concerned about ensuring that our assets were properly protected as we moved into the later stages of retirement. She described the general framework of what she had been developing, and she used the word protection 4 times in the first 3 minutes. After the 4th time, I said, "What are you protecting us from?" Melanie said, "There are various risks that people in your position face. Litigation, long-term care costs, estate complications." I said, "I have no pending litigation. I have long-term care insurance that Deborah and I purchased 8 years ago and that James Obata has reviewed as adequate. My estate documents are current and have been reviewed within the past 12 months. What specifically are you protecting us from?" Melanie looked at Deborah. Deborah looked at the table. I said, "I'll ask again. What are you protecting us from?" Neither of them answered. I reached into the folder I had placed on the table when I sat down. I put 3 documents in front of Melanie. The first was the corporate registration for Aldrich Property Holdings, LLC, with Deborah's name as sole member. The second was the letter of intent from Meridian Development Group, with the purchase price of $2.8 million highlighted and the market value of $3.2 million noted in James's handwriting in the margin. The third was a 1-page document James had prepared that described, in precise chronological order, the sequence of events from the formation of the LLC to the Meridian letter of intent, to the commissioning of the transfer agreement to the current meeting. I said, "The building is in an irrevocable trust as of 10 days ago. The LLC has been dissolved. Meridian has withdrawn. Nothing in the proposed structure can be executed." Melanie looked at the documents. She looked at Deborah. Deborah said very quietly, "Dale." I said, "Tell me what you are protecting us from, Deborah. Tell me specifically." She said, "I was protecting us." I said, "From what?" She was quiet for a long moment. Melanie said nothing. There was nothing useful for her to say. Deborah said, "I was protecting our future." I said, "By selling the building I built for 35 years to a developer for $400,000 below market value without telling me." She said, "The money would have been ours. We could have." I said, "Deborah, the building is not only a financial asset, it is a school. Children go there every day. Teachers go there every day. The lease agreement I signed with the foundation is a promise I made, and it is worth more to me than the difference between $2.8 million and $3.2 million. I paused. "And you knew that. You have known that for 35 years. She was crying quietly now. She did not say anything else. I stood up. I said, "Melanie, I have no interest in pursuing any legal action against your firm. The work you did was legal in its execution, if not in its intent. But the matter is closed, and I would ask that you consider it so." Melanie nodded. I looked at my wife. I said, "I'll be home when you're ready to talk. The real conversation, not this one." I walked out through the glass doors into the March morning, and I sat in my car in the parking garage for a while before I drove home. Deborah came home at 2 in the afternoon. I was in the garden, which I had been working in more since retirement than at any other point in my life, because the garden requires the kind of sustained attention that I had spent 35 years applying to the school and that I had not yet found another adequate use for. She stood at the edge of the garden for a moment. Then she came and sat on the bench near the rose bed, and I put down the trowel and sat beside her. She said, "I'm going to tell you the truth." I said, "I would like that." The truth was smaller and sadder and more understandable than the scheme built around it. Deborah's sister, Patricia, had been in financial difficulty for 2 years, a combination of medical debt and a failed small business that had left her in a position from which she could not recover without substantial help. Deborah had been helping her quietly from our joint accounts, small amounts that had accumulated into a sum that she was frightened to tell me about because she had been frightened of my reaction, and because each individual transfer had seemed manageable and the total had grown without her fully accounting for it. The total was $140,000 over 18 months. She had believed, apparently, that a sale of the building would generate enough to replenish what she had taken and still leave us financially secure, and that I would never need to know about either the transfers to Patricia or the sale that was meant to cover them. I sat with this for a long time. I said, "Why didn't you tell me about Patricia?" She said, "I thought you'd say we couldn't afford it." I said, "Deborah, Patricia is your sister. We have been financially comfortable for 20 years. I would have said yes." She said, "I didn't know that." I said, "Yes, you did. You have known me for 41 years. You knew." She did not say anything. I said, "What you didn't know was how to ask. That is different from not knowing the answer." She was quiet for a long time. Then she said, "I'm sorry." I said, "I know you are." James handled the financial resolution over the following 3 weeks. The $140,000 was acknowledged, restructured as a family loan to Patricia with a repayment schedule that Patricia agreed to without hesitation, and documented thoroughly. The estate documents were reviewed and updated. The building remained in the trust. Nathan and Claire both knew, because I told them, because they deserved to know. Those conversations were difficult in the way that necessary things are difficult, and I will not describe them here because they belong to us. Patricia called me 3 weeks after everything was resolved. She said, "Dale, I'm sorry you were put in this position because of me." I said, "Patricia, you were not put in a position because of you. You were in a difficult situation and you asked your sister for help and she gave it to you. The problem was not the help. The problem was the secret. She said I didn't know she was keeping it from you." I said, "I know you didn't." Deborah and I went to counseling. We are still going. These things do not resolve themselves in a single conversation or a single month, and anyone who tells you otherwise has not been through one. What I can tell you is that we are still married, and that we are still eating breakfast together every morning, and that the rose bed in the garden is the best it has been in 4 years because I have been paying attention to it. I am 69 years old. I spent 35 years running a school built on the understanding that trust is not a feeling. It is a practice. It is something you build through consistent action over time, and something you lose through a single significant betrayal, and something you can, if both parties are willing and patient, rebuild through consistent action over time again. What Deborah did came from love. I believe that entirely. She loved her sister and she loved me, and she was caught between those two loves in a way she could not navigate honestly. And she chose a path that she believed would protect everyone, and that required her to deceive one of the people she was trying to protect. That is a very human failure. It is not an excusable one, but it is an understandable one. What I want to say to you, if you are a person who has discovered that someone you love has been managing a secret that involves your assets and your future and your trust, is this. The secret is almost never about what it appears to be about. It is almost always about something smaller and more frightened and more human. Find that thing. It is where the real conversation begins. The building is still there. Children go there every day. The trust will ensure they keep going there for 20 years after I am gone. That was always what it was for. Deborah knows that now. She knew it before. She just forgot, for a time, that knowing something and acting on what you know are two different things, and that the gap between them is where most of the damage in a life tends to live. Tell me in the comments, has someone you loved kept a secret that changed everything? I want to hear from you.